Welcome to Crestview Community TV's Court TV. I'm Ryan Hardy, your Crestview Community TV legal analyst, and today we're watching a miscellaneous court date / VOP court date. You're going to see, by VOP we mean violation of probation, and you're going to see a lot of people this morning who are, a lot of them are going to be incarcerated because they've violated their probation. When you violate your probation, you're not entitled to a bond. Doesn't mean you can't get one, it means it's harder to get one. On a new law violation, most people are entitled to a bond, absent some major circumstances. When you violate that probation, though, you're not entitled to a bond, but you can get one. But that leads this court date to having a lot more inmates. Now, when you're called to the podium, a couple things you can do. You can enter a plea to your VOP and say, yes, I did it, I violated my probation. And you can get sentenced. You can ask for a continuance. Let's set this down the road, maybe try to work out some details, maybe try to work out a deal. Or you can ask for a contested VOP hearing, which will be set at a later date in one of the afternoons of this miscellaneous date. Now, VOP hearings are very hard to win. It's a different standard of proof. We don't see a lot of them because it's rather easy for the state to prove if you violated your probation or not. So you're not going to see a lot of contested VOP hearings. Now, in addition to the violations of probation in the mornings, you're going to see some other smaller, shorter hearings, things like bond hearings, or things that don't take a lot of time, normally 15 minutes or less on these morning hearings. Anything longer than that is going to be set to the afternoon.
Supervised through JCS, so misdemeanor probation, so that may be where the confusion is. So that should clear up.
So this is considered a felony VOP?
Right. It's still in felony court even though you were supervised by misdemeanor probation.
Okay, because the charges were reduced to misdemeanor.
Right.
All right.
Yes, sir.
Thank you.
Confusing, I understand.
Yes.
Thank you, sir. Mr. Notes?
Good morning, Judge.
Good morning, sir.
I've got Cameron Lane. Last name is Weafer, W-E-A-F-E-R.
Okay, they're bringing her out.
It might be right under a mistake. Because I showed it that she represents someone on one case.
Yes, sir. It's number 10 on my document. So, Mr. Noakes, you're substituting in for the Regional Conflict Council?
Judge, I got appointed June 20th, so 2 days ago at about 4:33. Then I got notice yesterday, and I have to be able to finish call. That's where I'm at now. We can go to the courthouse.
Okay.
But I was curious. He's got another case that Regional Conflict still represents him on, which is 22 CF 1570. I don't know what the state's offer is. I don't even know how long Mr. Weaver has been in jail, but
Okay, let me check with Madam Clerk as far as, was there a motion to withdraw by the Regional Conflict Council in 1570?
I don't see one. I only see one in the 71 case.
Okay, so Mr. Weaver, at least at this time, Mr. Noakes represents you on your 22 CF 71 case. That's the aggravated battery. And Regional Conflict Council still represents you on the drug possession act case. So you'll come back again this morning when the Regional Conflict Council's here. We'll talk about whether they're going to seek to withdraw and whether Mr. Noakes will be representing you on both of your cases. But as far as the 71 case, Mr. Noakes, what do you wish to do on Mr. Weaver's case?
So, Judge, actually, he's on probation under 22 CF 71. It's a misdemeanor. So I didn't know if the state would consider credit for time served and terminate probation for credit for time served.
Good. Okay. Yes, ma'am.
Judge, not at this point, not based on the allegations for the violation.
Okay.
And then, Judge, the Regional Conflict Council is Katie Jaquette, and it's my understanding she's not going to be in court this morning. She's going to be there at 1:30.
Okay.
So is there any way to pass Mr. Weaver until 1:30 today?
Yes, sir, certainly. Okay, so you'll appear back here this afternoon? It's actually probably at 2. Well, arraignments are at 1:30, but we can do it at 1:30 or 2:30. You think Ms. Jaquit's going to be here at 1:30?
That's what she told me yesterday afternoon, Judge.
Okay, so Mr. Weaver, I'll see you this afternoon at 1:30 on both of your cases, and both of your attorneys will be here, okay?
Yes, sir.
Good, thank you, sir. Thank you, Mr. Note.
Thank you, Judge. Have a good day.
Thank you, you too. Jared Hoskins, 17 CF 3122, 19 CF 1206. Good morning, sir.
Good morning, Your Honor. How are you doing?
Doing well, how are you?
Good.
Does the state have an offer from Mr. Hoskins?
Judge, in reading through the report, the state doesn't feel that we would be able to prove, if we were to go to a violation of probation hearing, that Mr. Hoskins would have the ability to pay the outstanding costs. That's the only basis for the violation today. So at this point, we'd ask that the violation of probation be dismissed and that Your Honor allow Mr. Hoskins to terminate from his supervision. That would mean that any outstanding costs would go to a civil lien, so.
Okay. Mr. Hoskins, I don't see any downside to that to you?
No,
You
sir.
agree to that?
Yes, sir.
So the violation of probation is dismissed. Your current supervision is terminated. How long do you think, do you want some time to try to pay off those financials?
Yeah. I recently, actually, going back to work, I broke my back a few years ago, and I finally got a letter from the doctor releasing me to go back to work. So I'm actually starting a job back
So
Monday.
why don't we say if you fail to pay the outstanding financials within 1 year from today,
Oh,
then
that's
they'll go to
fine.
a civil lien.
Yes, sir, that's fine.
Okay.
So my probation is terminated today because
Yes, sir.
it's not supposed to be until July 17th.
It's terminated now.
Yeah?
You're off probation.
Awesome.
Okay, just don't forget the money, because then it'll pop back up in a year and it may affect your
And I
driver's.
can pay that here?
The clerk's office, yes. sir.
All right.
Thank you,
All right,
sir.
thanks a lot.
Jason Neely is next. Jason Corey Neely. I can see Mr. Neely. Raul Silvas, Raul Falcon Silvas, 21 CF 213 and 21 CF 1311. Morning, sir.
Hey, how are you?
Good, how are you?
I got all my community service hours, plus I got like an extra, like 20. I got,
Okay,
the
hold on one
cop.
second. I just don't want you to say anything that'll hurt your case. Let's hear what the state has to say.
Judge, the state's requesting that Mr. Silvas, if he would admit the violation, that would reinstate his supervision and extend it to run coterminously with his supervision in 22 CF 113. My understanding is he would be scheduled to terminate in 2024.
113, it's not 1311,
No, it's another case that's not on the docket for today.
so it's 21.
22 CF 113.
Okay, what would his adjudication be?
It looks like he's already been adjudicated, Your Honor.
Thank you, Mr. McKinney.
Yes, sir.
Mr. Silvas, so you have the right to an attorney if you want me to appoint a public defender if you qualify financially. You have the right to waive that and waive your right to an evidentiary hearing where the state would have to prove your violation of probation. You can accept the state's offer and appoint an attorney. You can go to an evidentiary hearing, a judge trial on the violation of probation. As I look at what the state's offering, the downside to you is you'd be adjudicated guilty of the violation of probation in these two cases, and your supervision would continue in those two cases until your supervision ends in 22 CF 113. So as I think about the downside, is that if you violated probation in the future, instead of just violating 22 CF 113 one case, you could be accused of violating all three of the probation, which then your sentence may be more. So you may want an attorney. It's up to you.
Are they gonna violate me for the money?
They're saying that you would admit the violation for the money, and that the only ramifications of that would be you'd be found guilty of violating probation in these two cases, and your supervision in these two cases would continue until the termination of your supervision in 22 CF 113, your third case.
Okay, good.
So does that mean, Ms. Davis, that his supervision is extended in these two?
Yes, Judge, and just to be clear, it's not just costs that were the basis for the violation in this case. He also needed to complete community service hours and show proof of a valid driver's license or eligibility. So it's really three different bases that were present before the court today.
I have all my community service hours, and I got like an extra 20 hours. So 50, I think I got
Mr.
7.
Silvas, do you want me to appoint a public defender if you qualify financially?
I don't know.
Well, every attorney in the room would say, get an attorney to advise you.
I thought this.
If you don't feel comfortable with what the state's offering, then I'd suggest it's going to cost you $150 in the long run, but it very well may be worth it to you, at least where you understand what you're doing.
I thought it was just, I was supposed to come here and just show you that I got my hours done. I don't have the money. I can't get a license.
Let me ask you this. If I continue this case, and there isn't anything done on these two cases now, between now and July 20th, you talk to your probation officer, you show them that you've done all your time.
I've already have.
Okay, well, they're not, as far as right now, probation shaking their head like this. They don't.
Mr. Becker's got
Okay,
all my
but hold
hours,
on.
and I have all my hours.
Okay, but hold on. Even if you do that, state's saying that you haven't shown proof of eligibility or proof that you've obtained a driver's license.
I can't get a driver's license.
Okay.
I can't afford it.
Okay, and that's where you'd have to show proof of your, and what is it, proof of what?
His eligibility,
Eligibility.
so he
Thank you.
clears off any kind of holds on the
Okay.
license.
So that would give you time to talk to probation about that and what it would take. So do you want to
Sir,
continue these two
I've been
cases?
trying to get a license for the last few years now, and I've asked in this courtroom, and I've asked other people if I
Mr.
can
Silvas, so
possibly.
here's your, you got more than two choices, but I think, one, I can continue these hearings and take no action today. You talk to probation between now and July 20th. See if you can work out those problems that probation is saying that you violated.
I've
And if
already.
you have, hold on, listen. And if you have, then you come back on the 20th, and the state may drop the probation charges against you. You can go that route, or I can appoint an attorney to represent you.
I don't understand why I wouldn't need an attorney. I thought
Okay.
this was supposed to be it.
Do you want to try to clear it up with probation between now and July 20th?
I've already cleared up my community service hours.
Mr. Silvers, you have.
Yes, I have.
As far as probation's concerned, you have. So that's why you either need time to talk to them for them to, yes ma'am, probation.
When did you
help
bring the paperwork to your officer, because it's not.
And Mr. Becker's got several copies, and I got copies that, I show you all the
Okay, well, he's not
copies.
in the office today, sir, so that's why I'm asking you,
I
what
can
day did
give
you
you,
come by?
I have them right here as well. They emailed them to his,
What day did, so you emailed him, you didn't come
no,
by?
I didn't, Miss Lenore at, American Legion did.
Okay.
And I
Have
have
you completed
those.
your, court costs?
That's the only thing I don't have is the court costs, but I do have all my.
Okay, so what I'm reading, Your Honor, that on 6/1/23, when he came in the office, he told him to bring his hours in before the court date, but he also was gonna ask for y'all to allow him to work his court costs off in community service, so that he would be able to finish this up.
Yeah,
Any objection to that?
Not objection.
Okay.
so I can do
So,
that.
Mr. Silvas, you can work off all allowable court costs. I'll see you back here on these two cases, the violation of probation, on July 20th at 9 o'clock. Talk to your probation officer. Tell them everything, the sales pitch that you're giving me.
No,
give
it's
to them.
not a sales
Hold on.
pitch.
No, but I want you, Mr. Silvas, to talk to them.
I
You-
already
yeah.
have.
Okay.
And-
Well, then, if we come back on the 20th and you haven't gained any ground with them, then I'm going to be marching toward a judge trial for the state to prove that you violated probation. And then I'm going to be asking you if you want an attorney for that.
Sir,
May I, as a friend of the court?
Yes, sir.
July 20th is not a miscellaneous date, it's your jury review date.
Right, but I didn't think that it would be so crowded as July 13th. I have a feeling that that's going to be so.
Okay, I just wanted to make sure.
That I'm consciously doing it.
Yeah.
Probation?
Can you come out of the office on Monday and bring copies of any hours? I'm showing 20 hours and 20 hours, .50 not in the computer. So if he has those, he can bring them by and we can get it verified and
Hold
entered.
on, you're talking to me, but Mr. I think you're directing it to Mr. Mr. McKinney, hold on. Mr. Silvas, if you listen to probation.
If you'll come by the office and make sure we have copies of it. I'm showing you still owe 20.50 hours. If you can bring it to us so we can get it verified and cleared out, we can take care of that. Also, he can tell you how many hours you need to work off your court cost, okay?
So
Can
you said
come by?
Monday, come in
Yeah,
Monday?
come by Monday, because he's not there today. Okay?
Miss Lenore emails him.
Yes, sir.
Mr. Silvas,
But he
the
didn't
court
get
will
it
see you
in.
back here on July 20th at 9. Thank you, sir.
Your Honor, may we call Ms. Maldonado so I can see what Judge Ketchell's court?
Yes, sir, absolutely.
This would be Felicity Maldonado, 22 CF 300. She's in custody. And after I sent the paperwork back, the state did make an alternative suggestion on the case. I'd like to advise Ms. Maldonado that before we proceed with a written plea.
Good morning, Mr. Silvas.
May I have a moment, Your Honor?
Yes, sir.
Your Honor, in explaining Ms. Maldonado, the benefits and detriments of the two options. She's going to accept option B. I'm going to interlineate through what's here before and writing a new plea agreement, which will be to asking the court to revoke and terminate the probation and sentence her to time served, but it will come with adjudication on the underlying charge, Your Honor. That's the trade-off here. Right. And Your Honor, I know this is a little bit messy, but I had typed it up with the original offer, and so now it's a little bit messy. But we're asking the court to revoke and terminate the supervision, sentence Ms. Maldonado to time served, $100 VOP fee, $150 cost of defense. I crossed through my X on the withhold and put a new X on to adjudicate on the underlying charge. The pre-sentence report will not be required. I'll pause and give Ms. Maldonado an opportunity to sign.
Maldonado, if you want, if you'll initial the handwritten changes on the first page of that, if you agree with it.
Okay. Just give me here and here. And maybe under the adjudication too. Yeah.
Ms. Maldonado, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ma'am, you can put your hand down. Ms. Maldonado, so did you read the plea agreement?
Yes, sir.
Do you understand?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
So, Ms. Maldonado, it sounds like that you have not been adjudicated guilty of a felony before.
So that means I'm not a convicted felon.
Correct. You would be a convicted felon if I accept this plea. Do you understand that?
Yes, sir.
Okay. You think it's in your best interest to enter this plea?
Yes, sir.
Ms. Maldonado, I do accept your plea. Before I finish that, any questions for me? So when you say a convicted felon, you will be considered a convicted felon after today.
So it's just a felony, that's it? On my record, that's it?
You will be a felony. On any forms that it says, have you ever been convicted of a felony? You have to say yes.
All right.
Okay. Still want to enter the plea?
Yes.
Ms. Maldonado, I do accept your plea. You're adjudicated guilty. Your current supervision is revoked and terminated. You're sentenced to credit for time served. You need to pay the $100 cost of prosecution, $150 public defender's fee. All in all, you need to pay your outstanding financial amounts. Now go to a civil lien after that too.
Would the court be willing to give 1 year from the day to day?
Yes. Ms. Maldonado, so if you fail to pay all outstanding financial amounts within 1 year from today, then they'll go to a civil lien or judgment. Okay? Ms. Maldonado, you do have 30 days to appeal this judgment and sentence. If you wish to appeal, it must be in writing. If you cannot afford an attorney to represent you for that appeal, one may be appointed for you. Do you understand your appellate rights?
Yes, sir.
And the main reason why I said that, usually I don't say that on time served, but it's because you're adjudicated guilty for the first time, so I wanted you to know your appellate rights. Okay? Thank you, ma'am.
Thank you.
Your Honor, may I approach briefly with Ms. Bergman on a matter that's not on topic?
I'm Wanda Roberts. For the last Last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100.
And those are all PD cases. Yep. Okay, so to the public defender, which cases do you wish to take next?
Judge, I think we do have one more unrepresented.
But that is going to be longer hearing because it's a forever, right?
Potentially, yes.
Okay.
Your Honor, I have a female named Shannon Moore.
Okay.
Mr. Kleins, you also have Mr. England up there, and he already filed his fingerprints, so that could be.
Oh, I didn't even.
I like it.
I think a piece of paper is going to stop that.
Your Honor, this is Shannon Moore. We did file a motion to set bond and to reduce our previously set bond cash or preferred. I talked with Mr. Gomez this morning. I believe the state's going to stipulate to this motion.
Okay.
That's correct, Your Honor.
And I'll get an order to the court today. From a case perspective, Ms. Moore was seen by the doctor this past week.
Right.
So we need to report. I really don't see the point of having her on the July 10th docket. So I would ask the court for a 1-cycle continuance.
I did see that probation raised the question of competency.
Yes.
And so you want it August 14th, August 17th?
Well, I would just ask for the September 11th docket, and if the competency report becomes an issue, we'll put it on an earlier docket.
Okay. Okay. So, Ms. Moore, I'll see you back here no later than September 11th. Stay in touch with Mr. Collins, okay? And the motion to set and reduce bond is correct.
Your Honor.
Yes, ma'am.
Ms. Moore, you're still on supervision, and you need to report immediately upon your release, okay? We got to know where you're living. Okay?
All right, good to see you.
Good to see you.
Your Honor, I do have somebody not in custody. He's not present. That's Peter Ingman. He was on for
He's on, Mr. He's on Zoom.
Perfect. We did get the fingerprints, and we have submitted them, Your Honor, so I believe everything should be squared away with his cases.
That's correct, Judge. He was just left on to get his prints taken, and those have been e-filed.
Okay, so no action needs to be taken from Mr. England.
That's correct.
Thank you, Mr. England. Thanks for appearing.
Thank you, Your Honor. Thank you, Mr. Klein.
Thank you. Good luck. Judge, I have a couple.
All right, you too, man. Awesome job. Thank you.
I have a few cases in the gallery. May I call those?
Yes, sir.
David Fitzpatrick. Mr. Fitzpatrick is approaching the 19 CF 675. The violation is based on a new misdemeanor. A C4 motion has been filed in that case. I've been tracking along with that. That's currently scheduled for July 5th. So I would ask to continue this until after that in case that motion to dismiss is granted in the misdemeanor court. I'd ask for the 13th of July.
Yes, sir. July 13th. Mr. Fitzpatrick at 9 o'clock, okay?
Yes, Your Honor.
Thank you,
That's
sir.
without subpoenas.
Yes, absolutely.
Eric Watkins. Mr. Watkins is approaching 21 CF 2598. Mr. Watkins is in a similar situation that we're waiting on the misdemeanor at this point. That misdemeanor in review of this morning was continued until the 10th of July. So I would ask for the 13th of July as a status date. If it's not resolved on that date, we'll probably set it for an evidentiary hearing. But the defense is asking for this to wait for the misdemeanor to go to trial. I'll defer to the state if they have any other recommendations.
I would say we'll just set it for the 20th instead of the 13th, since, the 10th is only a few days before that, and so we have enough time to communicate between each other.
So, Mr. Watkins, I'll see you on July 20th at 9 o'clock.
July 10th. Thank you, sir.
Yes, sir. Thank you.
Sure thing. And Judge, I do have a bond hearing with Mr. Sargent, who is in the gallery. Do we want to call that before we get to inmates?
Yes, sir, that's fine.
Judge, Mr. Robert Sargent is present before the court. And to give the court a background on Mr. Sargent, I'm sure the court's aware, but to make record of it, Mr. Sargent was originally placed on GPS monitoring. There were issues with the GPS monitoring, and the court did issue an order removing the GPS, but imposing house arrest conditions because of the removal of the GPS monitoring. I do want to call Mr. Sargent's mother as a witness to the witness stand, as she is, and along with Mr. Sargent's father, the guardians that are home with him every day. And the motion was intentionally light on facts because I'm not with him every day. So I would like to get some testimony from his mother.
Okay. And you're seeking to delete the house arrest, correct?
Yes, Your Honor. Basically, I'm seeking to delete the house arrest and maybe modify to include some curfew or other options if the court will allow that.
Okay.
But I'd like to call Mr. Sargent's mother at this time.
Yes. Good morning, ma'am.
Can you raise your right hand, please? Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Ma'am, can you please state your name for the record? I'm going to ask you to please speak up, given that...
You can hold that microphone closer to you, too. Yes, ma'am. Thank you.
And how do you know Mr. Sargent?
He's my son.
Does he live with you? Is Mr. Sargent currently on house arrest sanctions as part of his bond?
Yes.
Tell us how Mr. Sargent is doing at home on the house arrest.
It's been difficult for him because all he has to do is watch TV and play video games and read books.
Now explain to the court a little bit about Mr. Sargent. Is he developmentally challenged?
Yes.
And are we all seeking an opinion from Agency for Persons with Disabilities about competency restoration in this case? Are you aware that Mr. Sargent has been found technically incompetent by this court and we're awaiting restoration plans from APD? When Mr. Sargent has to comply with house arrest sanctions and report to pretrial services, who takes him to those appointments?
I do.
And Mr. Sargent being at home without option to go anywhere else, how does that affect Mr. Sargent on his daily life?
He's frustrated that he can't go anywhere and do things as he's used to doing.
If Mr. Sargent were not on house arrest sanctions, what are the things that he would normally be doing that he cannot be doing while he is on house arrest?
He'd be going to the movies, he'd be going to the park, he could be going to different stores, going to the mall, visiting friends. So it's put a...
Are these things that would be normal things for him to do prior to being placed on the house arrest sanctions? Were there issues with the GPS monitor, even though there's not currently a GPS monitor on Mr. Sargent? Were there issues with that that were addressed with pretrial?
I think it just, that things would come off and he would get frustrated with them. The straps, they would come off a lot and he would get frustrated with them and knock them off. Not knowing he was not aware that he was violating or he was doing that. He was just frustrated.
So is Mr. Sargent's house arrest sanctions imposing an additional burden upon you and Mr. Sargent's father?
It is financially because we're all the time having to buy games for his video games or, like say, buy books or different things to keep him occupied.
So the outlets that he would normally have and going to do additional things, he's precluded from doing on these sanctions. And that is specifically what you're asking this court to, in essence, modify to include a curfew or additional safeguards that the court would seek to impose. Is there anything else you want Judge Brown to know related to your son and your situation before he makes a decision?
Yeah, our son lives with us. He doesn't drive. We have to drive him everywhere he goes. He's not a flight risk. He doesn't need to be on house arrest.
No further questions.
To the state, questions for the mother?
No questions, Your Honor.
Okay, thank you, ma'am. You can step down. Mr. McKinney, any other evidence?
No, Your Honor, just argument.
Any evidence from the state?
No, Judge.
Okay, Mr. McKinney, argument?
The defense well knows the seriousness of the charges here. And we know that the court specifically made the decision to place Mr. Sargent on house arrest sanctions given the removal of the GPS monitor. We understand that. The family wished for me to address this with the court given that that's impacting their daily life, impacting the things that Mr. Sargent can do. Unfortunately, he is in a holding pattern awaiting competency restoration, and we need a plan from APD, or we need to have direction from APD on whether or not we need an additional expert, which will take additional time, related to his situation in competency restoration. It is not as clear-cut or as quick as a standard person going into a conditional release plan, given that APD is involved. So the request from the family here is to relax the house arrest sanctions and modify that to include a curfew to allow Mr. Sargent more freedom of movement to do the things that he would normally do to keep him occupied during the day so that they don't have to be with him all the time and in that setting at home. But we'll stand by our request.
Thank you. To the state.
Judge, we've had a couple times that this case has been before the court with the defendant's family asking for some sympathies about the situation regarding this. The state's concern is a community caretaking perspective. He was on probation for battery on a person over 65, and then we have 2 cases of pretty intense written threats that were done reportedly by Mr. Sargent. So the level of detail that was given in some of the threats that were made are very concerning. So that's why initially, when Mr. Sargent was released on bond, it was with the GPS monitor to make sure that my victims are specifically that they're protected in this situation. So that was modified. I don't have the benefit of reading pretrial services report. It looks like it was something that was a communication that was, I guess, sealed or something. And so Your Honor removed the GPS and changed it to house arrest sanctions to continue to protect the community, but also to help the family through the situation of the GPS, particular problems. But as My concern at this point, though, is are we in the correct situation of Mr. Sargent receiving services from home for his competency restoration services? Are we becoming in a situation that, if in reality, we need to march forward with some further evaluations through APD to see if in reality we may be in a situation that we need to look at some kind of inpatient program through APD for these competency restoration services. I know, and looking through the last report that was done by Dr. McDonald, it seems in my reading of that she was somewhat on the fence of which way we should go. It seems that we needed to start on this path of attempting home services, but my concern is if we're starting to deal with some behaviors that are difficult for his family to control, some frustration, things like that, then maybe we're not in the right setting for Mr. Sargent to receive these services.
Mr. Sargent, and to your mom. I did do my homework. I read through the arrest reports because that's the only evidence I have other than your mom testifying. And I do have real concerns about public safety.
Yeah.
I understand what the state's arguing. I understand what you're arguing. I can't imagine the burden that it's putting on your family. I hear your mom saying she'd like for you to go to parks, movies, mall, visit friends. I understand that. Let me ask this of the state. If the court modified so that Mr. Sargent had some kind of curfew, but the time that he was out, he had to be supervised by his parents or somebody that we said, and he could go to the parks and movies and mall, would that be something that would be palatable to the state?
Potentially, Your Honor, I know there was in some of the paperwork, it showed that Mr. Sargent was going to a day program. So I'm not sure the status of that, if he's still going to that program.
Yes.
If so, I mean, I'm not sure then, that for the state, the curfew that we would request is especially the victims that I have that are in the most fear would be the Martial Arts Academy. And so that would be a program that would open around 3 o'clock and teach all evening. So I would ask for a curfew beginning at 3 when that would open. I'm not sure that it would be exactly what they're looking for in this situation.
Okay. So is the state saying that it would be satisfied with just a curfew from 3 p.m. until 6 a.m.?
No. Yes, Judge. And we would ask that he be, if he's not in attendance of that day program, that he be supervised by one of his parents. I'm not saying that both of them have to, but at least one. And I think the state would also request that he not be allowed to possess any weapons, because that was one of the threats. There was weapons involved.
Yes, ma'am. Okay. So, Mr. Sargent, your motion is granted in part to modify your bond. You'll be on house arrest from 3 p.m. each day until 6 a.m. the next morning. That'll be your curfew or house arrest. The day program is offered by who?
It's through the ARC program.
Okay.
What are the apps?
ARC, and 82.
Okay, so, so other than when you're at home on your curfew, you can be out only at an ARC day program or be supervised by one of your parents. At no time are you able to have access to any weapons. Okay. So that's the way that your bond's modified.
Okay.
And Mr. McKinney, if you'll prepare a proposed order.
Yes, Your Honor, I'll prepare an order for the court. And as far as scheduling goes, the court is due to see Mr. Sargent again on the 10th for pretrial. This isn't a case that's ripe for pretrial. I would ask for this to be set on the 13th in the afternoon if the state will allow for a hearing, or do you want to set that in the morning?
As far as the
Status.
So I was going to say that we could, I would ask to go ahead and address that at this point and proceed with the additional evaluation that Mr. McKinney was suggesting.
The route that we're in, the path that we have in front of us on our next status date, which I would ask for the next available, which would be the 13th at 9 a.m., would be if APD gives us an opinion and in writing that we can circumvent the evaluation by an APD doctor because of his prior history with APD. We've done that in cases in the past and streamlined this to where he goes straight to competency restoration. That's what we're trying to do. If we do not get that from APD, or we do not get that opinion from APD, then we would have to seek an outside evaluator that works with APD. Typically that's Dr. Pritchard in this area. But I'd like to set a hard date of when we have to have a decision made on do we need an additional expert or not.
Okay. So we'll continue the underlying case until September 11th, the pretrial, and have a status conference at 9 o'clock. Why don't we do it on July 20th? Is that okay?
That's fine, Judge.
On July 20th. But as far as what the court announced, as far as modification of the bond probation.
Your Honor, his mother has questions. She's confused about what was said.
Okay.
Father.
Okay. May I have a moment, Judge?
Please. Mr. Sergeant, it's nice to see you in a jacket. Thank you, sir. Thanks for dressing up for court.
And Judge, Mr. Sargent's question for the court really is.
And Mr. Sergeant, the father.
Correct. And make clear on the record. If Mr. Sargent standing next to me has a curfew and has to be supervised by a parent from 3 p.m. to 6 a.m.
No, he's on house arrest from 3 p.m.
Correct.
to 6 a.m.
And
he's
that,
got during other than those hours that he's on house arrest.
And other than those times, he has to be supervised by a parent.
Or be in the ARC day.
Or be in, correct.
Correct.
So during the time period in which he is on curfew, the question that the family has is, can the family go out and do things with Mr. Sargent? I mean, if they want to go out and eat dinner, is that permissible? Because as of right now, they cannot do that, given the way that the court is structuring this and trying to get out ahead of things.
Good question. Yes, ma'am. To the state?
Judge, I would be fine with that, but I think we do need to make sure that I don't see in the prior rulings from the court, I don't see that we had any imposition of no contact with the victims. So if we do this, then I would ask that there's no contact with the victims, no trespass at the businesses.
and we would have certainly no problem with that. The family is attempting to act like a family and go out and do things, and they don't want to violate the court's order by going out as a family to do something and without Mr. Sargent at home.
But if we do what you asked, and it's really, there's no curfew, it's just he can only be with his parents all that period of time.
That is correct. So I want to make sure we get the language right the first time.
Right. Ms. Davis, is that what you intend?
I think we can still call it a curfew, but that he is allowed to leave under supervision.
Okay. No contact with the alleged victims and no trespassing at the businesses or any other place, residence or place that they frequent. And if you want to put any of the addresses from the arrest reports in there, that'd be good.
Yes, Your Honor. I will document the order with the specific victims and their addresses so that it's very clear, and include language that if he is to leave the home during the curfew period, that he must be supervised by a parent.
If he leaves the home at all, he's got to be supervised.
Correct. Correct. Okay. Do you understand?
Yes. Okay. And thank you, Mr. Sargent, for asking that. I appreciate it. Okay, and so, Mr. Sargent, I'll see you back here on July 20th at 9 o'clock. Stay in touch with Mr. McKinney. Thank you, sir. Okay, yes, ma'am, Allison.
All right, so we're going to start with Robert Wallen.
Okay. We also have Miranda Rice. It's on Zoom.
She's connecting with audio.
Judge, this is Mr. Robert Wallen before the court in 23 CF 1146. Mr. Wallen is on the docket for a bond hearing. However, we have reached an agreement in this case. Mr. Wallen has reviewed the written plea agreement and he is signing it at this time. The terms of the agreement that have been reached, Mr. Wallen would enter a plea as charged. The state agrees that this is.
Yes, sir.
The state agrees that this is a constructive possession and the possession of firearm by convicted felon, so that there's not a minimum mandatory sentence to be imposed. The sentence to be imposed would be an adjudication of guilt, credit for time served. Mr. Wallen would forfeit the firearm. There would be $515 in court cost and $150 cost of defense. We would ask for a period of 6 months for Mr. Wallen to pay off those amounts before anything is sent to collections or judgment.
Okay. Has Mr. Wallen been found guilty of a felony in the past?
Yes, Your Honor.
Thank you.
May I approach?
Yes, sir. Mr. Wallen, if you'll raise your right hand.
I'll do the best I can.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do, sir.
Thank you, sir. You can put your hand up. Mr. Wallen, did you read the plea agreement?
Yes, sir, I do.
Do you understand it?
Yes, sir, I do.
Did you sign it all?
Yes, sir, I do.
Mr. Wallen, I do accept your plea. You're adjudicated guilty. You're sentenced to credit for time served. The subject firearm is forfeited. All monetary assessments mandated by statute or county ordinance are imposed. That's the court cost.
Mm-hmm.
You'll need to pay the $150 public defender's fee. If you fail to pay those amounts within 6 months from today, then they'll go to a civil lien or judgment.
Yes, sir, I'll have that paid in less time than that.
Okay, good. Thank you, sir.
Thank you, sir.
Next is Billy Williams.
Judge, this is Mr. Willie Williams before the court in 22 CF 2643. Mr. Williams is on the docket after being deemed competent to proceed at Florida State Hospital and sent back to the Okaloosa County Jail. So the court, in reviewing that paperwork, would need to find Mr. Williams competent.
The court does find Mr. Williams competent to proceed.
And then I can reference to the court that I have met with Mr. Williams and we've had normal, appropriate conversations about his case. I have no concerns at this point. And given the position that the court has found Mr. Williams competent to proceed, Mr. Williams has reached an agreement with the state. And Judge, he is executing a written plea agreement, which I have discussed with him and which he has reviewed in the back. The terms of the agreement are a plea as charged. Adjudication will be withheld. He will be placed on 2 years probation. Special conditions would include an anger management course, a mental health evaluation, and any recommended treatment. No trespass at any Wendy's. Random urinalysis while on supervision. Standard court cost of $515 and a $150 cost of defense. May I approach with the plea agreement?
Yes, sir. Thank you.
May I approach?
Yes. Mr. Williams, if you raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you, sir. You can put your hand down. Mr. Williams, the one thing that Mr. McKinney didn't state was that if I accept your plea, you'd have to pay the $40 per month cost of supervision. Do you understand that?
Yes, sir.
Okay. Did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you sign
Yes, sir.
to the state?
Judge, we would agree to community service work in the actual courthouse.
Okay, good. So, Mr. Williams, I do accept your plea. Adjudication is withheld. You're sentenced to 2 years probation. You need to enter and successfully complete an anger management course. Submit to a mental health evaluation within 30 days from today. Any treatments recommended, begin that within 60 days from today. Have no trespassing at any Wendy's restaurant. Submit to random urinalysis. You need to pay the court cost, $150 public defender's fee. You can perform any community service work to work off any allowable expenses, and you'll need to pay the $40 per month cost of supervision. Thank you, sir. Good luck to you.
All right, thank you, sir. Thank you, Your Honor.
Next is Joshua Van. I do have a question on Robert Wallen. He's on our 130 for plea. I handed you
Right, and he's already pled, so he can be removed from the 130.
Okay.
And who represents Miranda Rice?
I do.
After this, we'll do the response.
Your Honor, this is Mr. Mann. We do have a resolution to resolve these 4 cases. In 23 CF 634, Mr. Mann is going to be entering a no contest plea as charged. In the 3 violation cases, 20 CF 2649, 20 CF 2539, and 20 CF 729, Mr. Mann is going to admit the violations of probation. The agreed upon disposition is that Mr. Mann would be adjudicated, and in the 364 case, that's the new law violation, will be placed on 3 years of probation. As a special condition, he must attend and complete the ART program. He will remain in custody.
Hold on 1 second.
Yes, sir.
What's the new case?
The new case is 23 CF 634.
Good, okay. And I'm sorry, he'll be...
Sorry, it's 3 years of probation. He will have to attend and complete the ART inpatient treatment program as a condition of probation. He will remain in custody until a bed becomes available. He will perform 48 hours of community service, be assessed $615 in court costs, and $150 in public defender fees. On the 3 VOP cases, his supervision will be modified. And the new term of supervision is going to be 2 years from today. Reinstate all prior conditions that haven't been satisfied in those cases. There will be a $100 VOP fee for each one of those cases, a $100 cost of defense for each of those cases. He's previously been adjudicated. May I approach it, please?
Yes, sir. Thank you. Mr. Mann, if you'll raise your right hand.
Yes.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you, sir. You can put your hand down. Mr. Mann, did you read the plea agreement?
Yes, sir.
Do you understand it?
I do.
Did you discuss it with your attorney?
I have.
Did he answer all of your questions?
I'm going to address it.
Yes, sir.
Sure, you got any questions?
No.
What he's asking about, Your Honor, is ART. My understanding is ART is not going to come transport him from the jail. So I'll talk with Mr. Gomez. His wife is present. She's done a lot of work to make sure that everything's lined up. I think the bed will be available next week. The morning that it's available, we'll submit it. Well, I'll have an order to the court before that, authorizing her to transport him to the program. That's the only issue that was still kind of standing.
If, for some reason, you know, you can't get a quick, first off, email me directly when you do that. If you don't get a quick response from me, if I'm not in the office or something, go to the duty judge and say, Judge Brown specifically told me to come to you to do that because of the sensitivity of time.
Yes, sir.
Thank you.
Yes, sir. You're welcome. So, Mr. Mann, I swore you in, correct?
Yes, sir.
Okay. I'm smiling because when Mr. Clance talked about your wife doing the work to make sure that you could be transported, she broke into a big smile and waved like this. And I believe, you know, she's a heck of an advocate for you. It sounds like she's pulling it together and making sure it works.
Absolutely.
So that's awesome. Mr. Mann, I do accept your plea. You're adjudicated guilty. You're sentenced in the new case to 3 years probation. You'll need to enter and successfully complete the art program. You will remain in jail until a bed's available for art. Perform 48 hours of community service work. Pay the court cost, $150 public defender's fee. In the VOP cases, you're adjudicated guilty. Your current supervision is modified and reinstated so that it's 2 years of probation. All of these sentences are to run concurrently, run at the same time. You need to pay the $100 cost of prosecution for each of the 3 cases and an additional $100 public defender's fee for each of the 3 cases. Mr. Gomez?
Your Honor, this is a downward departure for the purposes of a legitimate, uncoerced plea bargain. I do have this.
Yes, sir. Thank you. Thank you, sir. Thank you, Mr. Mann. Good luck to you, sir. And thanks for your wife being in. Yeah, thanks. Yes, sir. Okay, now we're going to do Ms. Rice.
Ms. Rice, can you connect to audio?
She may be the telephone there, and I muted her before, so I can unmute. Maybe.
Ms. Rice, are you also on the phone?
There you go. Good.
Ms. Rice? Okay. We're set for a violation of probation arraignment today. This is based on a new charge, which is set in court on August 14th. So I would enter a denial and ask for a court date to be set after August 14th.
Okay, and it's a VOP.
I'm sorry. I'm having audio issues. Can you repeat that?
The case before Your Honor is a violation of probation arraignment. The reason for the violation of probation is a new misdemeanor, which has court on August 14th. So we would enter a denial, which is like a not guilty plea for the violation of probation, and ask for this to be rescheduled until after Ms. Rice goes to court for the misdemeanor case.
So do you want the hearing?
Okay.
You want it on July 20th or August 14th?
Judge, if we could have it on August 14th, that's when she's already due in court on the misdemeanor. So we should have an idea of what progress has been made in the misdemeanor.
Okay. So, Ms. Rice, I'll see you back here on August 14th after your misdemeanor case, okay?
Your next court date
Yes.
will be the August 14th. Do come in and talk to me ahead of that date.
Yes, sir.
Thank you, ma'am.
Okay, thank you. Have a good evening.
You too.
Next is Benjamin Lee.
Your Honor, I was talking to Mr. Lee here. This is going to be a plea to the bench. The issue that we have right now is we are waiting for an answer from Phoenix House. I did talk to my investigator this morning, and she has talked to Phoenix House, and the holdup really is they need to know what kind of certain medication he's on. So I would ask the court to allow us to enter the plea today and see if we can pass this to the afternoon to see if we can get a final answer from Phoenix House. And if not, I was just talking to Mr. Gomez. When the court had mentioned you're going to be free next week, I thought, well, that's great, because if we have to push it to next week, I'm free anytime in the afternoon next week. So, and I was telling Mr. Gomez, even if he wants to appear by Zoom, I don't know what his calendar is in the afternoons, but I'll be free to come over here in person if we need to do it next week. But I'd like to try to do it today, this afternoon, if possible. But I would like to go ahead and enter this plea for Mr. Lee. This is an open plea to the bench. He's aware there is no agreement with the state, and this is going to be a non-departure situation with your decision of departure. Your kind of approach.
Yes, sir. And that was going to be my question. What does the score sheet show?
The score sheet shows a 51 point. Hold on now.
It's 51 months and change. So it will be a downward departure situation.
It's 50.1, Your Honor.
Okay. And we'll talk about that a little bit, Mr. Lee. Mr. Lee, if you'll raise your hand, wait a minute, hold on. Let's talk to you, and then I want to talk to them, and I want you to understand everything. Mr. Lee, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Put your hand up. Mr. Lee, did you read the plea agreement?
Yes, sir.
Are you currently under the influence of any drugs, alcohol, or medication?
No, sir.
How far did you go in school?
12th grade.
Did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Do you understand that if I accept your plea, that you're waiving the right to a trial by jury?
Yes, sir.
Do you believe it's in your best interest to enter the plea?
Yes, sir.
Are you entering the plea today freely and voluntarily?
Yes, sir.
Has anyone forced, threatened, or coerced you into entering the plea?
No, sir.
Has anyone promised you anything regarding what the sentence may be in this case?
No, sir.
The opposite of that. Has Mr. Kleins or anyone else told you, Mr. Lee, if you do not enter this plea, you shall be sentenced to some certain sentence?
No, sir.
Do you have any questions for the court or your attorney or the state?
No, sir.
Okay. So let's talk about the score sheet and the downward departure. So it's my understanding, hearing from the state and Mr. Kleins, that the score sheet shows 50.1 months in prison. And in order for the court to go lower than that, I'd have to find a valid reason for a downward departure. Have you had the opportunity to go through reasons for downward departure with Mr. Clemens? Has he talked about that with you?
Yes, sir.
Okay. Do you have any questions for the court or Mr. Clemens or the state about the downward departures? What he's going to seek, he's going to come back to the court if I accept this plea and say, Judge, the reason why you shouldn't sentence Mr. Lee to 50.1 months in prison is because of mental health treatment. Some reason for a downward departure. You've had those discussions with Mr. Clemens?
Yes, sir.
Okay.
So the court's aware, Your Honor.
Please.
I met with Mr. Lee yesterday. He and I have talked about the mechanics of a downward departure sentence, how that operates, the burden of proof. Yesterday I went over specifically some case law that explained what needs to be proven. And then I also went over the legislative sentencing policies, I guess you could say, in 921.002. So he's aware of what we're going to be arguing, and frankly, we're going to be asking one of the bases for the departure is going to be an off list. I don't have any case law saying it's not appropriate. So, but there's going to be one list-based request for the departure and one off list-based. So,
okay. Mr. Lee, when he says list in the statute, it gives a list of reasons for downward departure. And then it says it's not exclusive. You can come up with other things. But one of the things that Mr. Clemens knows is that a lot of the appellate cases have said things that aren't on the list don't really qualify for a downward departure. So Mr. Clemens is going to have an uphill battle on whatever that is that's not on the list, because the norm is it may not qualify for a downward departure. I don't know what it is. I haven't heard any evidence. I just want to make sure that you understand all the information I can give you about your plea before I accept it. So do you understand that?
yes, sir.
Still want to enter the plea?
Yes, sir.
Okay. Mr. Lee, I do accept your plea. I find that you're alert and intelligent, that your plea is freely and voluntarily entered, that you understand the nature of the charges against you and are represented by competent counsel. You're satisfied with Mr. Klein's representation?
Yes, sir.
Okay. Of whom you state you are satisfied. I find that there is a factual basis for acceptance of the plea. So I'll see you this afternoon at 2:30, okay?
Okay.
Thank you, sir.
Gregory Nelson?
Thank you. Oh, you know. Good, how are you?
You do.
Your Honor, this is Gregory Nelson. He's going to be entering a plea to resolve 23 CF 528. As part of that, he's also going to be entering a plea to resolve a misdemeanor case. And that case number is 23MM 2023.
Okay.
In the 528, the CF case, Your Honor.
Okay.
Mr.
Klein, before you go forward, why don't you look at what I just handed from the clerk, and let's make sure everybody knows what's going on.
It's for this case. I don't know.
Okay. Can I explain this?
Absolutely. Yep.
Your Honor, I was just explaining to Mr. Nelson, I think the appropriate thing to do would be to have the warrant served, because we're going to plead to the case that warrant exists for, or we can end up pleading and the warrant be withdrawn. It's up to the court.
To the state, which would you rather?
I'm sorry, repeat that again?
It's for contempt of court, which I'm assuming is based on the contact.
Yeah. And what would you want to do?
either serving with the warrant, how long would it take to serve him?
Or pleading.
Depending on the people that serve it.
I mean, could he be served this morning?
He could be served this morning, yes.
Okay. So do you want him served and he comes back later this morning?
I think that's the best thing to do, because I hate to withdraw it and then he gets out and moves.
Come back later this afternoon.
Yes, well, Mr. Klein, are you going to be here this afternoon?
Oh, yes, I'm going to be here.
Okay.
Yes.
1:30.
1:30 is arraignment, want to do it at 2:30? Well, or either one. Are you going to be here at 1:30?
I will if I need to.
Well, if you don't.
I don't have anybody on the arraignment docket.
Okay, so you'll be here at 2:30?
I'll be here at 2:30.
So I'll see you back at 2:30, Mr. Nelson.
Okay,
This
so I'm going to
afternoon.
serve them in the morning, and then once we should square it. Okay.
Nelson for the 2:30.
You should still.
That's just your paperwork.
Thank you.
Thank you.
Next is Matthew Jones.
Mike, do you mind finding out folks in the gallery who are they waiting for?
Judge, I do have a friend waiting on the next person up, Mr. Russell, that's an individual in the red shirt. Judge, this is Matthew Jones with me, and we've got two cases set on the docket today, one on the arraignment docket and one on the arraignment docket for a violation of probation. He's here in 21 CF 1324 and 21 CF 1620. On the case scheduled for this afternoon, we would acknowledge the receipt of a 2-count information, waive its formal reading, enter a plea of not guilty. That case is going to be scheduled for the 10th of July, and we're going to be entering the denial of the violation of probation today and asking for the same court date, the 7/10, to track together in hopes that we can reach an agreement ahead of time, given that Mr. Jones has been incarcerated in the Department of Corrections for quite a while at this point on another case. So we're hoping that we can reach an agreement ahead of time and resolve this matter.
So, Mr. Jones, I'll see you back here no later than July 10th. But if, Mr. McKinney, if you want to accept some offer from the state, Mr. McKinney can get you on the document for you. Okay. Thank you, sir.
You don't need him for the 1:30?
No, we do not need him for 1:30.
Mr. Russell?
Judge, this is Justin Russell before the court in 22 CF 2232. Judge, I was making sure Mr. Russell didn't have any additional questions since he signed this back on the 16th. But we have reached an agreement or set for early plea today. Mr. Russell is going to be entering a plea as charged. He will be adjudicated guilty. He will be placed on a period of supervision, which will be 24 months community control with GPS monitoring, $515 in court costs, $150 cost of defense. This is an agreed upon downward departure. Mr. Russell, in all candor to the court, does have an additional case in Escambia County that he has to go deal with. So I've explained that to probation, that he will likely not be released today, but he understands that he must report to probation in Fort Walton upon his release, even if that's in Escambia County.
Right, so he'll need to report that day that he's released from Escambia County. If he's released before 5 o'clock, at 5 o'clock, or here in Fort Walton, it's after 5 o'clock and on a day, and 8 o'clock the next morning.
Yes. May I approach?
Yes, sir. Mr. Russell, if you raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? You have to say it verbally.
Yes, sir.
Okay. Mr. Russell, did you read the plea agreement? Did you read the plea agreement?
Did you just explain it to him?
Okay, did you read it?
When we sent him back to jail on the 16th.
Yes, sir.
Okay. Do you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Mr. Russell, do you have any questions about the plea agreement to the court or your attorney of the state?
You have to answer that.
No, sir.
You just seem very tentative. I just want to make sure. So if I accept your plea, what is your sentence going to be in this case? Just basically, what are you going to be sentenced to?
24 months, community control.
Mr. Russell, I do accept your plea. You're adjudicated guilty. You're sentenced to 24 months community control with a GPS monitor. You need to pay the court costs, $150 public defender's fee, and the $40 per month cost of supervision. The court does find that this was an uncoerced plea, and that's the reason for the downward departure. Thank you, sir. Good luck to you.
Thank you.
This way, sir.
One question, what town is he going to live in?
Sure.
Fort Walton.
Next is John Smith.
Mr. Smith.
Judge, this is Mr. John Smedley before the court. He is set for a status court date after I was appointed in 23 CF 1014. His additional cases in which he is undergoing competency restoration training at the Okaloosa County Jail are also on this docket for status. After being appointed in 23 CF 1014, I did go back and review the report from Dr. Zeman, and I acknowledge that it was over 6 months ago. Therefore, we would need to get a new evaluation for Mr. Smedley to determine if Mr. Smedley remains incompetent to proceed, and if he does, what the proper placement would be, either at Florida State Hospital or less restrictive means if they are still available. That's the long way of me saying I think that we need to continue this matter so that we can have Dr. Zeman reevaluate Mr. Smedley so that we have a current report to work off of and have an opinion at that point.
Any objection from the state?
No, Judge, we concur with that position.
So how long do you think we should set it out?
Given that Mr. Smedley has already been evaluated in the past by Dr. Zeman, I would hope that that would happen sooner rather than later. I'd like to keep hands on it if we could have a status court date set for all of his cases on the 13th of July.
Okay.
I am going to be filing a motion and seeking an order from the court appointing Dr. Zeman as an evaluator so that it is a court-ordered evaluation. Hopefully that should speed things up as well.
Okay. So, Mr. Smedley, I'll see you back here on July 13th, okay?
Judge,
Mr. Smedley?
because I've had some communications with, he's been working with Mr. Barnes at the county jail doing the competency restoration. Based on my communication with that and how imperative I think it would be in Dr. Zeman's evaluation, especially if we're talking in terms of whether he remains in jail, is released, or goes to Florida State Hospital, I would ask for an order from the court that pretrial services prepare some type of analysis or update regarding the competency restoration training that Mr. Barnes has been doing. So I'd be happy to prepare that order and send it to Mr. McKinney to look over before we send it to Your Honor. But I think that it's too important that we get it done as soon as possible and get that report from Mr. Barnes so that way Dr. Zeman can be fully apprised when he's doing his evaluation.
I think that's a great idea. The more information we can get to that expert, the better.
So we establishing kind of a deadline for Mr. Barnes to get that report.
So to be clear on the record, the state is seeking an order for Mr. Barnes to report to the court the progress made during the competency restoration and set in a time period on when that letter or report would come?
Yes, my recommendation would be by next Wednesday. I would think that that would be sufficient time, based on my communications with Mr. Barnes, for him to prepare that report, and that would give enough time for Dr. Zeman to receive it before he does his evaluation.
If you'll put next Wednesday's date in that proposed order.
Yes, Judge.
The defense certainly concurs that time is of the essence, and that would be highly appropriate.
Good. Thanks, Mr. Smith.
Do I know it?
We'll take a 10-minute recess and we'll come back and finish up in the morning. Again, Mike, if you'll see the folks in the gallery are waiting on if we can take them next.
All rise.
Is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045. Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at DaysTirePros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hi, I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Fat Boy's Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
So I'm going to seek a continuance until July 13th to look at additional placement of Project Hope or additional options for Mr. Smith to see if those are options. So I'm asking for a continuance at this point on the violation of probation.
Okay, and so then, if it's not resolved on the 13th, then we'll set it for a hearing with subpoenas, correct?
Yes, sir.
Okay. Mr. Smith, I'll see you back here no later than July 13th. Thank you, sir.
Next is Darrell Shaw.
I filed a motion to withdraw in this matter. Conflict has arisen. We're asking the RCC to be appointed. This is a case where multiple conflicts were created in a single instance, so I can't say with any degree of certainty that Mr. Shaw will be represented by RCC, but the PD can no longer represent him.
The motion to withdraw is granted. Mr. Shaw, so the Regional Conflict Council will be appointed to represent you. Is Ms. Jacob going to be here this afternoon?
She may not be.
I think we already discussed earlier that she'll be here at 1:30.
She may not be because she entered a,
I'll find out. I'd say keep him at this point, and I'll find out and then let Madam Bailiff know.
Keith Shaw.
Yeah. Keep her for a few minutes and let me just find out if she'll be here or not.
Okay. Is there an offer to Mr. Shaw that Ms. Jacob could go over with Mr. Shaw? Or?
Judge, it's an incursive offer. And Mr. Shaw has been restored to probation multiple times, and my understanding the last time he was told by Judge Stone that this is the end of the train. So at this point, we're pretty steadfast in it.
Mr. Shaw, all that doesn't get any traction with the court today because that's not before the court. I'm just trying to figure out procedurally, is it good for me to get you with your attorney today? It doesn't sound like there's any real big upside to that. So I do appoint the Regional Conflict Council. The next miscellaneous date I have similar today is July 13th. So I'll see you back here no later than July 13th in the morning.
Till then, ma'am.
Thank you, sir.
Next is Wendell Bright.
I apologize for excusing myself before I was done. Does the clerk show anything else for me before I go back up to Judge Ketchell's office?
Anything else from Mr. Moore?
That's all I have.
I don't either, Mr. Moore. Thank you.
Thank you, Your Honor.
Wendell Bright.
10:39.
Oh, Mr. Wright. Good, how are you?
Judge, Mr. Wright is on the docket today, and it was noticed for a Nelson hearing. Mr. Wright filed a motion, pro se, alleging, I think, three grounds for a Nelson hearing, so that's the reason for the hearing.
Okay, let me get mine. Yes, sir, got it. Mr. Wright, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand out. So, Mr. Wright, I did read through your motion. You're saying that you're seeking to discharge Mr. McKinney as your attorney, that he failed to provide you with complete discovery, that he refused a favorable plea offer until after completing a psychological evaluation, and that he failed to investigate and move to dismiss certain charges. But tell me, now that you're under oath, why you believe that the court should find that Mr. McKinney rendered ineffective assistance of counsel.
Well, Your Honor, discovery exhibits, these cases, I have cases that go back all the way from 2020 in all this, and we talked about this as far as bringing the discoveries up and things like that and getting these charges dropped and taken care of, and then we had said that, he had said to me, instructed me, well, here's what we're going to do, we're going to just put these aside right now, and we're going to work on this case, but I just, only on one case number did I just receive my motion of discovery on the case number, I don't know exactly which one it is. Anyways, 1776. Yes, Your Honor, I just received that. When Mr. McKinney was out of town for Mr. Klein's in your courtroom record. I think the instruction it went different. You know what I'm saying? When he instructed me, I think it went different. I think at some point the rug was snatched. I don't really know what happened, but the instruction from day one until where we're at now is not how it was instructed to me, and I didn't understand, and I thought we were signed. And then apparently the day of that, Ms. Davis, I think, took the plea agreement she set off the table that day. I think that was on a Zoom hearing day, and we were still waiting on the mental health evaluation. And that day, I believe that they were experiencing technical difficulties at the jail and things, because I didn't understand her taking the deal off the table that day, Your Honor. And you even said that day in the court hearing that there was technical difficulties they were having. Could I hear you? Things like that. I would have signed the plea agreement. You know what I mean? And I feel like I don't know what happened. I really don't. I don't know what happened between him and the state.
Did you say you did sign a plea agreement?
No, sir. No. Plea agreement, I believe, was offered to me.
Okay.
At the same time, we were supposed to have a mental health evaluation and a drug evaluation. And you agreed for the mental health evaluation. She didn't have no objection to that. And we were waiting on that. And then I guess the man didn't get it delivered in time, or Mr. McKinney had just got it on his desk on the day she took the deal off the table, and instructed me right here to wait until he read it, the mental health evaluation. And so by the time we got that, I haven't even seen that. I don't even know what was said there, what went on there. By the time he seen that, we come back and there was no deal on the table. She was ready to hang me on the cross, you know what I mean, in a trial. And then that wasn't, you know, I don't understand how it went from a deal to a no deal. I guess the district attorney changed in the end here, from what I understand, correct? I guess she changed on us. Like I said, I've never seen any emotional discovery on any of my other cases. And as far as moving forward with the cases that should have been dropped in round 3, there's several cases where people were coming forward and were going to drop the charges. There was a case where the victim actually was putting money on my books at the county jail, visitation, actually did a power of attorney to help me. Now, I know that he's playing both sides of the fence, but you can't do that. You know what I mean? Yeah, that's not how that works. So
okay. This is focus on what Mr. McKinney did or didn't do.
Okay, well, this is what he didn't do. I don't think he didn't investigate those charges, and those charges should have been dismissed. The burglary charge, I believe, should have been dismissed, because not only did I get mail at the residence, I stayed there quite often with my girlfriend. So that was never dealt with. The thing with the vehicle, the stolen car, I presented to him evidence from the 2020 case that would have proved innocence on the car that allegedly said I stole. Lease agreements that I asked him to get, and information I gave him to try to get these things to investigate it, that should have taken care of the 2020 charge and had it dismissed. So the 2020 charge, we should have had that dismissed. The burglary charge should have been dismissed. And the stolen car should have been dismissed. But he failed to do that for me, or even go into that, because I guess at some point the state just started focusing on what they felt like they knew they could take me to trial on and win. I don't know why they wanted to, you know. So we got case from 2020, and we jumped from 2020 all the way to 2021 to the end. But this is all one little issue. It all comes in together. If it was investigated properly, they would see where it all ran together. One situation, one misunderstanding went from this to this to this, and we led here. Also, when the burglary charge happened, I also explained to Mr. King that if he would notify the pretrial release lady, Miss Tiffany LaCoy, he would have found that I called her and told her everything that was going on before it went on, before it happened. I also explained to Mr. McKinney that Billy Clark, as a bondsman, would have explained to him that I called him as well. I stayed within notification of all of those things. When this charge came about, I called everybody. I even called dispatch the night of the alleged burglary and had dispatch put me to Mr. Dylan Gentry's voicemail because he didn't answer his phone, and I left him 2 very long messages explaining to him, sir, he's looking for me everywhere. You got to talk to me. This is not what's happening. This isn't true. So all these things I presented to him. Now they were sort of basically, it seemed like we're being brushed under the rug right now because we'll deal with that later. Well, now we're at the point where we can't deal with it later. You know what I mean? This lady seems like she's upset with me. Ms. Sadler, I don't know. I don't know where she came from. Now they've got a PR after 2 years on me that I don't know. You know, I had a bond hearing with you at one time, and you gave me a bond, and then the state, this was before Ms. Davis or anything came, because I've been through like 3 state's attorneys, 2nd judge. I've been in county jail for 24 months. And she stood up and gave me a hold for failure to appear. I wasn't on any type of probation thing. I should have been entitled to a bond. The failure to appear came about the morning of the incident, before court, because I was trying to come to the courthouse after speaking to Mr. McKinney. That also wasn't ever brought to light. I spoke with Mr. McKinney 2 days before court, and he said, Mr. Wright, he said, come in, don't miss court or nothing. He said, this is not as serious as it looks, because at first they were talking about I had a home invasion or something at the place I was staying, and that wasn't what it was. It was already coming downstream from there. And I said, okay, Mr. McKinney, well, I don't have a history of any type of this behavior, any type of anything that I'm really being charged with. Definitely don't have any type of failure to appear history. Failure to appear came that morning of. And it was at 8:47 in the morning when all this began. I was supposed to appear in court in front of Judge Stone at 9 o'clock. So I was charged with failure to appear when I'm already in cuffs for another charge, you know, for that morning. So I couldn't barely make it to court. The officers blue lighted me right at the courthouse, close to the courthouse. So, I mean, it's just been an array of different things that I think that because of the COVID and because of so many different things that happened, and he has such a caseload, I felt like that this is just, he couldn't provide the counsel that needed to be provided in this delicate cases like this. This is my life, Judge Brown. It is. I'm not a bad person. I needed help. I need something other than a life sentence in prison. I mean, this is not what we ever spoke about. The instruction that he gave me was not this. We were going from, if these other charges, he explained to me one time, he said, well, if we do get these other charges dismissed, which he never put in anything for that.
I don't want you to
right, I got
disclose attorney-client things that you don't need for this hearing. So, Mr. McKinney, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Mr. McKinney, how do you respond?
What does the court wish me to respond to first?
Whatever you want to.
Judge, if we look specifically at the motion that's been filed, states 3 issues. And the first issue is that Mr. Wright, was not provided a complete copy of his discovery at the jail. It's going to be my practice, and I believe any competent defense attorney's practice, not to give a full copy of discovery to clients at the jail unless it is absolutely necessary, given the fact that inmates at the jail can read other people's paperwork and become witnesses in their case. I always prefer to review discovery with clients in the attorney-client room where there's some level of confidentiality. Mr. Wright is correct that he did receive a full copy of his discovery in the 1776 case, which is the case that was set for trial, provided by Mr. Kleins, when Mr. Kleins went to meet with Mr. Wright ahead of his docket day. Count. Issue 2 here.
So, Mr. McKinney, did you go through all the discovery on each case with your client?
Judge, I have reviewed the discovery in each case with Mr. Wright. and I've completed depositions in all of the cases.
Okay.
In issue 2, I believe is really the crux of what Mr. Wright is saying here, and that he would have signed the plea agreement. This is an offer that has been discussed on the record. With Mr. Wright present, the issue of Mr. Wright not being present for his pretrial, where he was on Zoom, I do agree that there were audio problems with pretrial with a Zoom appearance, and that was the date in which Ms. Davis revoked the offer for a downward departure in 5 years for all cases. Obviously, I can't be standing at the jail and in court at the same time. So, I mean, I will point out that, yes, Mr. Wright is correct that there were audio problems with Zoom on the date of his pretrial. He came back in person on docket day with Mr. Klein's because I was out on docket day. And then when we came back on jury trial review, the state said that they had already revoked the offer. They refused to put an offer back on the table.
So were your instructions at the pretrial to accept the 5-year offer?
If we look at the language there, I'm never going to instruct a client that they have to or that they cannot sign a plea agreement. That is always going to be up to the client on whether or not they choose to accept an agreement and believe that it's in their best interest. So I would disagree with the language there, that Mr. Wright didn't have the ability to enter into the plea agreement that was offered. There is some difficulty there with Zoom that I acknowledge. It's difficult to have reasonable conversation over Zoom at pretrial when there are moving pieces involved. We did meet in person at the jail prior to pretrial and discuss the offer. But I would disagree with the language that I instructed him not to accept it. Issue 3 relates to a different case number. That relates to 21 CF 1772, which is not the case that was set for trial on the latest trial docket. In that case, Mr. Wright is charged with an attempted burglary. Mr. Wright is unhappy that I have not filed a motion to dismiss in that case. Motions to dismiss typically come in 2 flavors. They're either B1 or C4. B1 is when there's legal issues for the court to decide. C4 is when there are facts and no facts at issue. Because if I file a C4 motion to dismiss with facts at issue, the state can easily file a traverse. I have deposed the victims or alleged victims in that case number. I'm aware of the situation involving the witnesses in that case, but I believe that the current state of the case is that if a motion to dismiss is filed, it could be easily dismissed or traversed by the state based on the depositions we've completed with one of the witnesses. So I would disagree that it's a pertinent avenue to file a C4 motion to dismiss an attempted burglary. When facts are at issue, that's why we have trials. Mr. Wright wanted to go to trial in that case first. It's an older case, and that was something I believe we made record of. But the state in this position does have the ability to choose which case they want to go to trial on first.
Thank you. Mr. Wright, anything else you want the court to know?
I don't know if I can put my life here.
May I, Judge?
Yes, sir.
Proceed.
Yes, sir.
Okay. Your Honor, I fight for my life. And would take the plea agreement. I tried to take the plea agreement. I don't know what channels got crossed or what happened here. I don't know if it was win this side, lose it. I don't know how. I'm not understanding a lot of this. I'm doing the best to study. I mean, you know, I'm trying to be knowledgeable of all this because this is my life now. And maybe I didn't at one time realize how serious my life was till it's almost over now. And I got kids that are wanting to come, you know what I'm saying? I wish the state would put the deal on the table. You know what I mean? I feel like we got to start if we can't. If she's not going to put the deal back on the table, then I need to start again. We got to start from somewhere again and try this again at some point because I know that with these other charges gone, my score sheet's different, things change. You know what I mean? I'm doing the best I can to study and learn. You know what I mean? I'm good with my hands. You know what I'm saying? And I'm trying to be good with my mind now because you know I guess fight or flight in life. You know what I mean? Daddy always told you, a scared man a key. You know what I mean? He gets you in the back corner, puts you in the corner. You know what I mean? And so I'm coming out and doing the best I can. You know what I mean? And
yes, sir. I
just think that Mr. McKinney just couldn't do what he needed to do, or had a different plan, and something happened. I don't know. I feel like that this has been ineffective for me. Really, at this point, it is right now. It is.
I don't find that Mr. McKinney was rendering ineffective assistance of counsel. So respectfully, your motion is denied. When you say he had a different plan, you know, he has discretion on, he has to consult with you and do different things with you, but just based upon the evidence that I've received, I don't find ineffective assistance. He has certain decisions that he has to make as an attorney, but he certainly has to get you information. To the state, is there any offer open to Mr. Wright?
No, Your Honor.
Okay. So are we going to trial, Mr. McKinney? I know that probably this motion slowed you down or stopped you from doing things.
Yeah, in reference to the motion related to the other case numbers, to make sure that we're clear on the record, since discovery was raised as an issue, does the court want me to provide a full copy of discovery in each case number to Mr. Wright? Is that his request?
I'm not ordering that. I think that, you know, that's up to you. I mean, I think the attorney's got to make that decision. If your client says that he wants copies of everything and you advise him that if it's open to everybody in the jail and all those things, again, I think it's a decision for the attorney to make.
Yes, sir. Your Honor will see Mr. Wright again on the 10th of July for pretrial. So I'm going to have a discussion with Mr. Wright ahead of that time, speak to the state, see exactly where we're at. But I believe that based on the work that we're still trying to do in getting the additional witness that we discussed right prior to trial, which was the reason for continuance, deposed, we're on our second attempt at that for the 30th of June. I'm hesitant to say, Judge, we're going to be fully prepared, 100% ready to go at this point because we haven't done that yet. So the court will see Mr. Wright again on the 10th of July. Once I do that additional deposition, make sure that we've got any additional evidence that the state has, and certainly I want to discuss that with Mr. Wright prior to seeing Your Honor again.
Okay. Mr. Wright, I'll see you on July 10th. We'll talk about whether we can go to trial.
All right, sir.
Thank you, sir.
Next is Michael Thompson.
Thank you.
Judge, this is Michael Thompson before the court. He's here in 22 CF 27 and 21 CF 2624. Your Honor, took a plea agreement from Mr. Thompson at our last court date. This plea agreement contemplates a resolution in the violations of probation. The sentence that's agreed upon with the state would be Mr. Thompson being adjudicated guilty after an admission to the violations and probation to be sentenced to 23.05 months, Department of Corrections with credit for time served. and that is a concurrent sentence between the two case numbers. And I'll say it again so that Mr. Wright makes sure that it's all over the record that he gets credit for all time served. And his probations will be revoked and terminated, and a $100 BOP fee in each case, and a total of $250 cost of defense. So may I approach with that plea agreement?
Yes, sir. Mr. Thompson, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can put your hand down. Does the state have a score sheet for Mr. Thompson?
Judge, I have to supply two different score sheets because we had some cases earlier this week for Mr. Thompson. So I'm going to be supplying both of those, separating them out.
Okay.
It will be a guideline sentence.
Mr. Thompson, are you currently under the influence of any drugs, alcohol, or medication?
No, sir.
Have you ever been treated for any mental illness or emotional disturbance, or are you suffering from any of those at this time?
No, sir.
How far did you go in school?
Graduated.
From high school?
Yes, sir.
Did you read the plea agreement?
Yes.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Mr. Thompson, has anyone promised you anything regarding what the sentence may be in this case?
No, sir.
Okay. Well, let me go back on that. The sentence is going to be 23.05 months, correct?
Yes, sir.
Okay. As Mr. McKinney or anyone else said, if you fail to enter the plea today and be sentenced to that 23.05 months in prison, that you'll be sentenced to 5 years in prison or 10 years or any other specific sentence.
No, sir.
Mr. Thompson, I do accept your plea. I find that you're alert and intelligent, that your plea is freely and voluntarily entered, that you understand the nature of the charges against you,
Yes, sir.
and are represented by competent counsel with whom you state you are satisfied. I find that there is a factual basis for acceptance of the plea. You're adjudicated guilty. You're sentenced to 23.05 months with the Department of Corrections, and that's with credit for all time served, and that's to run concurrently, run at the same time between each count. Your prior supervision is revoked and terminated. You need to pay the $100 cost of prosecution for each of the two cases, and a total of $250 public defender's fee. All outstanding financials will go to a lien or judgment. Mr. Thompson, you do have 30 days to appeal this judgment and sentence. If you wish to appeal, it must be in writing. If you cannot afford an attorney to represent you for that appeal, one may be appointed for you. Do you understand your appellate rights?
Yes, sir.
Thank you, Mr. Thompson.
Jade May next.
Your Honor, Jade May is approaching the podium. We're going to have to put this on the 230 docket. Mr. Gomez needs to file an amended information adding account prior to the entry of the plea. We do have a disposition agreed upon, but the paperwork's got to be done first.
Mr. May, I'll see you this afternoon at 2:30.
Okay, thank you.
Thank you, sir.
Old name is Angela Rangel.
Hello, Mr. Heath. Good morning. Good morning, sir.
Sorry to be tardy, I was with Judge Wells.
And I have to smile, because you have to be at Judge Wells's court first, right?
First. That's his preference, right?
I think it's a little more than a preference.
Yeah.
Preference is not right the word.
There, yeah.
Good morning, Your Honor. This is Angela Rainville. She's here on a violation of probation, some lesser included misdemeanor offenses. I think we're moving toward the resolution. I spoke with Mr. Gomez today, who's now prosecuting the case. I need to actually go over that with Ms. Rainville. Is there what's the court's next available docket that we might be able to park this case on?
The next I've got is July 13th. Is the offer to Ms. Rainville Is he going to keep her in jail for that period of time?
The offer would contemplate her being in jail through the 13th, correct? And now, that is a misdemeanor. Since this is a misdemeanor violation of probation, would the court entertain a plea in absentia since it's only a misdemeanor?
Any objection?
No objection.
So that okay. So could we just set her on a control date for July 13th?
Let's do July 13th at 9 o'clock. I'll see you no later than that unless you enter a plea, and then I can do that without a court hearing. Okay? Thank you, ma'am.
Next in the gallery is Shirley White.
Mr. White, how are you?
How you doing, sir?
Good. Let me grab my homework that I went through on your karate. Mr. White, do you still want to represent yourself?
No, sir.
Okay. You want to be represented by a public defender if you qualify financially?
Yes.
How much money do you make per month?
There's about 1,500.
Okay, I do appoint the public defender to represent you. Mr. White's case number is 22 CF 1779.
Is this on the 9 o'clock docket, Judge?
Yes, sir. It's under the pro se, and Mr. White initially was saying that he wanted to represent himself. Number 9 on my docket on the original 9 o'clock docket.
Well, Judge, is this a new law offense or a violation of probation?
It's a new law.
It's a new law. So in 22 CF 1779, Judge, is this scheduled for July 10th for a pretrial?
Yes.
Then I'd ask to leave it on the pretrial date of July 10th.
Okay, why don't we ask, does the state have an offer for Mr. White?
Yes, Judge. He scores 52.58 months in prison, and that's been the offer since last year.
Okay. Mr. White, so I'll see you back here on July 10th at 9 o'clock. Stay in touch with Mr. McKinney, okay? Thank you, sir. House of Business. Do y'all want to do any of the 1:30 arraignments for the inmates, or you want to wait until 1:30?
Don't look at me. Don't look at me.
No, I'm happy to look at you.
I would say we can go ahead and
Yeah.
bring him out, as long as Mr. Gomez doesn't object.
Judge, I represent Ms. Riggs in two case numbers, 23 CF 1006 and 23 CF 1136, and I was at the table furiously writing a plea agreement for Ms. Riggs. That's something that we discussed prior to, except for a few of the moving pieces. But the court want me to finish the written plea agreement or go through this on the record.
What is the sentence?
It would be a withhold adjudication and 2 years of probation. That is something that I have discussed with Ms. Riggs at the jail prior to today.
I'm fine doing it orally.
So that Ms.
You said there was a moving pieces, make sure that Ms. Rigg understands.
For Ms. Rigg's benefit, if Ms. Rigg were to enter a plea of no contest and each charge, which is 3 third-degree felonies, adjudication would be withheld. That means that she would not be adjudicated guilty of those 3 felonies. She would be placed on a period of 2 years probation, which is standard reporting probation, which would include the $40 a month cost of supervision, and they would include special conditions. The special conditions would be 48 hours community service work, no trespass at FUBAR. She must complete an anti-theft class, have no contact with the victim, and the moving pieces are the restitution amounts of $415.16 in 23 CF 1136 and $501.81 in 23 CF 1006.
I'm sorry, what were the cents and the $416?
16 cents.
Thank you.
The state is seeking a minimum payment of $200 per month. Yes. Okay. Yes. And the moving pieces of the minimum payment and those dollar amounts. And speaking with Ms. Rigg at the podium, I believe that she understands and accepts those additional conditions, and would seek to withdraw any pleas of not guilty on the other case number and no pleas of no contest as charged, to be placed on 2 years of probation with a withhold adjudication for the terms that we just announced.
Okay. Ms. Rigg, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You can put your hand down. So, Ms. Rigg, let's talk about it since it's not in writing. If I accept your plea and you accept it, then you would be waiving your right to a trial by jury on any new cases. Do you understand that?
Yes, sir.
Have you ever been on probation before?
No.
Have you had the opportunity to talk to Mr. McKinney about what is entailed with probation?
Yes, we did discuss that with you when you saw me before.
So here's what I've got written down, and if you've got any questions about anything, let's talk about it. 2 years probation, $40 per month cost of supervision. You'd have to pay the court cost, $150 public defender's fee, perform 48 hours of community service work, have no trespassing at FUBAR, the restaurant/bar on Okaloosa Island. You have to enter and successfully complete the anti-theft course, have no contact with the victim. Is the victim the entity FUBAR? Or who is
No,
it?
Judge, I have 2 victims. I'm trying to write it down. There's one in each case. I'm writing down the name and address for Madam Clerk's benefit.
Okay, if you can just tell me the names, where I can make sure Ms. Rigg understands.
If I can pronounce them.
Okay.
Sean Kiernan Felony, and that's in 23 CF 1136 and 23 CF 1006. It's I'm not sure if it's Michael or Michael Morgan.
Okay, so, Ms. Rigg, do you understand if you enter this plea and I accept it, that you have no contact directly or indirectly with Ms. Pelosi or Mr. Morgan during this 2 years of probation? And that's yes?
Yes.
You'd have to pay restitution of $416.16 and $501.81, and you'd have to pay that at $200 per month. Really want to talk to you about that. You going to have the ability to pay that?
Yes, my family's going to pay all that at once. They've asked if it could be paid all at once. I was asking if it can be paid all at once because they've been asking if it can just be paid off at one time.
You can certainly pay it off sooner than that.
That's
yes,
why.
ma'am.
Well, the sooner the better. Because they were asking if they could have paid it before court, but Mr. McKinney had told me no. But as soon as they can, they are ready to pay it off.
Okay. Have any questions for me or Mr. McKinney or the state? Okay. Do you still wish to enter the plea?
Yes.
Ms. Riggs, I do accept your plea, withhold of adjudication, and the terms that I just stated, unless Madam Clerk needs to hear it again.
Then we would need to state the court cost and the public defender's fee.
I mentioned that before. Yes,
Yes,
making sure. Yes, sir. Thank you, Ms. Riggs. Do you have any questions?
It's $150 public defender's fee, right?
Correct. One case and a 100 on the second case. For a total
I'm sorry, you don't put that.
All of this, just one time.
So there's 2 court costs and then $250 public defender.
Yes.
Yes, ma'am. Good, thank you, ma'am.
I can approach Madam Clerk with the addresses for the victims.
Good. Yes, ma'am.
An address and a map of the new report, continue the report collections, full police and justice.
Read all the
Which
beginning.
is going to have a
Sir.
documentation on it.
No.
Sure. That's it. I'll have this one do that.
So, Mr. McKinney. Doing well, how are you? Mr. McKinney, do you wish for me to appoint the public defender if you qualify financially? You're charged with, well, let's first get an attorney appointed. How much money do you make per month?
I've been in DOC for the last 4 months, so I haven't been making anything.
Okay. I do appoint the public defender to represent you. Mr. Gomez, is there something I need to know?
Oh, no, I just, because of my case.
Good.
Your Honor, there is a second case for Mr. McKinney that he is represented by Sidney Brown. I assume Ms. Brown's not going to represent you in this case? I don't know, I haven't spoke to her.
I sent Ms. Brown an email yesterday and didn't get a response. I asked the same question. I don't think so. We've only seen a notice of appearance filed in the, I think it's the 2019 case.
Your Honor, there is a 4-count information, including PBO offense in count 1. I would enter a not guilty plea on behalf of Mr. McKinney, waive the formal reading. I would ask this be placed in the September 11th docket, given the nature of the charge.
Okay. Mr. McKinney, I'll see you back here no later than September 11th. If your attorney wants to file a motion before that date, then I'll see you at that hearing. Thank you, sir.
Next is Darius Wingate.
Okay, thank you.
Judge, this is Darius Wingate before the court, 23 CF 241. This information that I've been handed is the actual warrant. Is there the information?
That's the only information I received.
May I step away, Judge?
Yes, sir. Sir. Hello, Mr. Wingate. Good, how are you?
I'm getting by.
I'm sorry?
I'm getting by.
Yes.
Judge, I do have a copy of the direct issue habeas, which is a 5-count information. We would waive its formal reading. We would enter a plea of not guilty. And we would ask for this to remain on the docket on July 10th for pretrial. I do anticipate that that's going to be more of a status, given the seriousness of the case. Counts 1 and 2 are each third-degree murder with a weapon. There are depositions already scheduled for next week that we're writing along with the co-defendants' depositions. So I believe that we've entered a plea of not guilty and we want to remain on July 10th.
Mr. Wingate, I'll see you back here on July 10th. Okay. Thank you, sir. I think that's all for the morning. We're in recess until 1:30 this afternoon. Thank you.
All rise. Person recess.